What I mentioned.
Yes.
And I have an urgent matter hearing in a court number 10. So item number 7, admission, may kindly be taken first number.
Okay.
Item 7. The appeal against conviction by the learned sessions of Vishnu Sahib under section 323 IPC, awarding 6 months imprisonment, and also 147 IPC, awarding 15 days imprisonment. The appeal may be admitted for hearing without medical evidence. The accused is convicted, and the ordered judgment dated 27/6/2025. It's session case number 45, 2016, section 447, 324, and 34. 6 months under section 323, and 15 days under section 147, smiley. 1 month.
What accused?
Both are brother matter, Suren Hazarika and
No. What
Ujjwal Hazarika.
accused in the trial? Suren Hazarika,
Both are
Ujjwal
brother,
Hazarika.
Suren Hazarika and Ujjwal Hazarika.
Come to page 48. Something wrong?
Yes, but
Huh? Something wrong, right?
Mhm.
These names are wrongly typed, perhaps.
That is the case, Suren Hazarika.
3 months, 1 month, 15 days. 3 months, 1 month, 15 days.
I
I he is already allowed to accuse a religion bail up to 20 feet, my lord. So they may kindly confirm. In IA case 10 is the bail order, my lord.
Right, Mr. K. Sharma, learned counsel for the accused appellants. And Mr. MP Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. Poster. The this criminal appeal under section 4152 ENSS is preferred against the judgment dated 27/6/2025 and an order on sentence dated 36/2025 passed by the Court of Learned Sessions Judge Vishwanath at Vishwanath Sarili Trial Court in Sessions case number 45 of 2015, closed up by the judgment and the order on sentence, the trial court has convicted the 2 accused appellants for the offenses under section 341, section 323 and section 323, read with section 34 of the Indian Penal Code, closed up, for the offense under section 323, read with section 34 IPC, section 323 IPC, read with section 34 IPC, the 2 accused appellants have been sentenced to undergo rigorous imprisonment for 3 months and to pay a fine of ₹1,000, in default of payment of fine to undergo rigorous imprisonment for another month. Post for the offense under section 341, IPC, read with section 34, IPC. The 2 accused appellants will sentenced to undergo simple imprisonment for 15 days. Post of the sentences are ordered to run concurrently. Post of. I have gone through the grounds urged in the memorandum of appeal. A criminal appeal is admitted for hearing The case records of sessions case number be called for. Issue notice returnable in 4 weeks. As Mr. Goswami has appeared, accepted extra copy of memo of appeal, 3 working days. Accused appellant shall take steps for service of notice upon the response number 2 by registered post with AD as well as by usual process within 3 working days from today. IA, the instant interlocutory application under section 430 within bracket 2 is preferred by the applicants seeking suspension of execution of the sentences passed against them and for their release on bail. Also, where the applicants as the appellants have preferred the accompanying criminal appeal number so and so. Full stop. Against the judgment and order that is so and so, so and so. Full stop. Concurrently লিখি দিব, concurrently লিখি দিব, full stop. The BNSS খন দিব. It is averred that after conviction and sentence, comma,
Last page is what of
45 of 2015.
there, but punishment is 6 months, 1 year, 1 month. That's the kind of 40.
Is 44 IA. Then 52. Paragraph 52. On the other hand, memo of appeal, page 48. Something wrong. Names are wrong. Oh. Okay. Page paragraph 52 G2 judgment or paragraph 52 G2 লিখা আছে হেতু লিখি দিব. 323 read with 34 আছে আর 447 read with 34. What is the equivalent provisions of section 389? That bail is to prefer an appeal
Appeal. It is
under section 430 subsection 3
not.
to prefer an appeal. So when you prefer an appeal, then it is for the appellate court to
Yes, my
give fresh bail.
It's short, not for the appellate court. Original court, my lord.
Uh-huh.
It is passed by order passed by the session judge because they originally say
That I understand. Earlier 389 subsection 3, if the conviction is below 3 years, right? Just you are granted bail
Yes.
to prefer an appeal,
Yes.
right? Now, when you are before the appellate court,
Yes.
right? Whether you are allowed to go on, remain on
But
previous bail or you have to
the
go.
date fix is on 25/7.
Huh?
So till 25/7, he was granted bail. madam.
Huh.
You
So
also
after
kind of
25/7,
see the
what
order,
is
page
the
10.
page 10
Page 10 is the
Page
bail
10
order.
also.
Page 10.
memo of appeal also?
Memo of appeal.
Memo of
I-
appeal. No, what I am asking is that you have to go for on press bail,
Fresh bail.
because
bail,
your
I-
submission is that to remain on previous bail. That is why I am examining it.
Yes.
I am granting you,
Yes.
Yes, you
but
accept
that
it because
not
they-
on previous bail.
Yes. Even the my lord previous
Because
bail also-
subsection 3 says
Yes.
so.
Yes.
Only to prefer an appeal. Am
Yes.
I correct or wrong?
Yes, my lord, but even then, even otherwise also, my lord, the previous bail is the last date fixed on 25/7, my lord.
Whatever.
That is also,
whatever.
my lord.
Now, up to that date, it was given. So on this
Whatever.
order, we have to obtain this bail order. will be
Having
executed
regard
with
to
disposal of
the contentions raised and the period of sentences imposed upon the applicants, appellants, this court is of the considered view that till pending disposal of the appeal, the applicants, the execution of the sentence says passed against the applicants, appellants can be suspended. Post up. Accordingly, it is ordered that the execution of the sentences passed against the applicant's appellant shall remain suspended till the disposal of the appeal, and the applicant's appellants are allowed to go on bail, subject to 10,000, 5,000 each, to the satisfaction of the learned trial court.
satisfaction of the trial court.
Trial court, 5,000 each,
10,000.
5,000.
For motion, item 1.
Yeah, please, Your Lordship. Lord, this, my lord, petition has been filed under section 447 PNSS, my lord, for transfer of sessions case number P2, my lord.
Transfer of
2023.
sessions case
My
number.
lord, Learned, Court of Sessions as Kukrajar to my lord, Fauzalim, my lord.
What
My
are
lord,
the grounds?
Grounds, my lord, I have taken one ground, my lord, that is, my lord, the Learned current, my lord, trial court, my lord, has no jurisdiction, my lord, lacks of jurisdiction, my lord.
Lack of jurisdiction.
Yes, my lord.
Okay.
Kindly, my lord, turn to page 20, the my lord.
Let us
deposition of-
first read the FIR.
My lord, page, my lord, FIR page 9, my lord, 9A.
Itu nibedan এই যে so নিম্নলিখিত আসামি জানে 30 তারিখ এজাহাৰকাৰী ঘৰৰ পৰা পলুৱাই নি পাঠশালা এলেকাত ভাড়াঘৰত ৰাখে বিশেষ সূত্ৰে এজাহাৰকাৰীৰ স্বামীয়ে এই খবৰ পাই পাঠশালাত গৈ আসামিজনৰ লগত কালি দেখা পাই চাৰিআলিকৰ সহায়ত ছোৱালীজনীক পাঠশালা পুলিচ থানাত পঠাই দিয়ে Okay, this is the FIR. Then charge sheet.
My lord, the LS
It was charge sheeted.
Yes, my lord, charge sheeted, my
Charge
trial is going
sheeted
on.
under
Charge sheeted under section, my lord, 376, 366, and my lord, 367, my lord.
three.
Now, my lord,
420, 420.
And my lord, now, my lord,
420. Let us see the charge framing.
366 and 376. 420 was, my lord, he was discharged from 420, my lord, during the search. I have
Now,
annexed the order, my
who
lord.
is PW1, page
My
20?
PW1, the informant, mother of the alleged victim. And PW2, my lord,
Let us read first PW one,
my lord, page, PW1, page 20, my lord.
is 20. Is 20 is the informant,
Yes, my lord.
under informant.
May I read, my lord?
Yes, yes.
My lord,
Okay, I am reading it.
my lord.
Yes.
Next page, my lord, page 22, my lord. Deposition of alleged victim, my lord. Not a single part of occurrence took place.
Let us
Kukazam.
read, then you
Kindly, my
make
lord.
submission.
Page 22, my lord. My lord, as per her statement, my lord,
What is the offense under section 366 IPC?
and 376, my lord, search has been planned, my lord, and
IPC.
he stated, my lord, madam, that all the incidents taken.
So
have
which
taken-
provision gives the jurisdiction to the trial
My lord,
court to
court
try
of-
an offense?
My lord, 197, my lord,
Hmm.
kindly turn to section
190.
197, my lord.
When the charge was framed, charge was framed when? 11/10/2000,
SARS frame, my lord, 10,
23.
11, 88, 11, 10, 23, my lord.
and this BNSS came into force when? 1/7/2024. Right? So at the time of framing of charge,
My
it was a CRPC.
My lord.
CRPC.
My,
Let us see CRPC.
my lord.
Just a minute, just a minute. Did the lady say it about her age? Huh?
My lord.
Did the lady,
My lord.
or did you cross-examine about the age of the lady?
My lord, is at the time of occurrence, my lord, she was minor, my lord. And in
At the
As
time
per-
of occurrence?
yes, my lord. At the time of she was admitted in my lord college, my lord, she was minor, my lord, above 17 years, my lord.
17 years.
Yes, my lord. Above 17, my lord, at the time of admission.
At the time of
Admission, my lord.
admission.
Admission.
At
my
the time of occurrence?
lord. That has not been specifically mentioned, my
Huh?
lord.
Three 366 says what? Omen. So it is not related to the age,
Yes, my lord.
right?
Yes, my lord.
Hmm.
— 177 CRPC, my lord.
We'll come to that. PW1 says she was taken from their house.
Yes, my lord. But
And PW2 says everything happened
it Bozali
in
and
Bozali.
Boroma
Huh.
when she was studying at Bozali College, my lord.
Huh.
And she has never been visited
Huh.
in my lord, Tukrajal, my
Hmm.
lord, since 2018 and
Huh.
to 2020,
So there are conflicting versions.
my lord.
Conflicting versions.
Versions, but my lord,
Huh?
my lord,
Back to the
It is-
matter, that allegation about 376, that is a different matter.
my lord.
But factor is that from where she was abducted
My lord.
with the intention to
But
commit such kinds of
my lord,
acts,
my lord,
right?
my lord.
Now, 177 if C is a minor,
my lord,
suppose,
my lord,
if 366 says
my lord,
kidnapping
kidnapping,
or abducting,
my lord,
the question is about age,
my lord,
right?
my lord,
If the lady
Hmm.
was minor,
my lord,
then she was under constructive guardianship, even if she stays in a hostel
my lord,
at Patsala,
my lord,
she is under the guardianship of
my lord,
her parents, right?
my lord.
Then there are two kinds of kidnapping. One is kidnapping from India,
My lord,
the other is from kidnapping from lawful guardianship.
that's
If a minor,
my lord,
the lady, then it is kidnapping from lawful guardianship.
my lord,
Even if she stays in a hostel, right? But constructively, the lawful guardianship of the minor is with the parents,
my lord,
right? So let us see 177,
Right.
ordinary place,
my lord,
CRPC,
my lord,
inquiry,
my lord,
ordinary place of inquiry or trial.
my lord,
You also read the subsequent provisions also,
my lord,
right?
Right.
178. A, where it is uncertain, because there are conflicting versions,
my lord,
PW1 and PW2,
oh, my lord,
right?
my lord,
Where it is uncertain in which of several local areas an offense was committed.
my lord,
Where an offense is committed partly in one local area and partly in another.
my lord,
C, where an offense is a continuing one and continues to be committed in more local areas than one. D, where it consists of several acts done in different local areas.
my lord,
It may be inquired into or tried by a court having jurisdiction over any of such local areas. Right? Then 79, consequence.
my lord,
Offense tribal where the act is done,
Hmm.
maybe Patsala.
my lord,
Consequence
my lord,
with the parents. They were having lawful guardianship.
my lord,
That can be done. That is why FIR was lost. FIR was lost there.
FIR is lost in
Because
Kokrajhar.
that is, they lost. Now, 181,
my lord,
subsection 2. Any offense of kidnapping or abduction of a person may be inquired into or tried by a court within whose local jurisdiction the person was kidnapped or abducted or was conveyed or concealed or detained.
my lord,
Patsala gives that.
my lord,
But similarly, conflicting version, mother says from our house. Now come to 4C, 460. 3 or 4. 400, perhaps 62. Read.
my lord, 400,
462.
60,
462.
462. My lord, proceeding in wrong place.
Hmm.
No finding, sentence, or order of any criminal court shall be set aside merely on the ground that the inquiry, trial, or other proceedings in the course of which it was arrived at or passed took place in a wrong sessions division, district subdivision, or other local areas, unless it is appears that such error has in fact occasioned a failure of the
So
case.
you allowed to proceed
My lord,
the trial,
my lord,
right? Somehow you could elicit something
Right.
during cross-examination,
my lord,
right?
Right.
You never raised this point regarding jurisdiction earlier. After cross-examination, you could elicit, defense could elicit something,
Right.
right? Which gives gives rise to a doubt regarding territorial jurisdiction. Now, what is the consequence? Nothing. 462 is clear,
my lord.
right? Now, only thing remains, what has occasioned the failure of justice? Nothing.
But my lord, My lord, when, my lord, the affair was lost, my lord, when the affair, at the time of lodging the affair, my lord,
No, question is regarding 447.
my lord,
Let us see 447. Because no wrong.
my lord,
If the judgment is delivered
my lord,
by this court where the trial is presently pending,
Hmm.
no wrong. Unless you show establish occasion, it has occasioned failure of justice. You submitted to the jurisdiction, you allowed the trial to proceed. You cross-examine PW1, then PW2, never raising that question. Now, 447. Whether it falls within A,
Hmm.
or falls within B,
B.
or falls within C.
my lord. My lord,
Which one?
my lord, I, my lord, and A, my lord,
Hmm?
that a fair or impartial,
Because that is why I put the question to you, the lady, the age of the lady,
my lord,
right?
my lord,
Lawful guardianship remains with the parents till she attains majority.
she was staying in hostel, my lord,
Still the lawful guardianship is with the parents, legal guardianship. It does not constructively legal lawful guardianship remains with the parents.
And-
Right,
and my lord,
right.
no, my lord, specific.
That is why I put the question to you.
Yes, my lord, but no specific date, my lord, when he was, my lord, allegedly kidnapped.
That is a matter of appreciation.
and my-
That we do not go into those aspects. The court is
Yes,
in
ma'am.
seizing of the matter. The Sessions Court is in seizing of the matter. So trial is proceeding. At the end of the trial, everything will be decided.
My lord,
But even if it is a wrong place,
and my lord,
now it does not, its judgment will not be rendered illegal unless you show and establish that it has occasioned failure of justice. Nothing.
but my lord,
We do not see anything.
whether, my lord, her statement, my lord, he was her statement
If
was
I say that
But
it
here-
does not, has not occasioned any failure of justice,
164 was taken, my lord.
that is a different thing.
So, my lord, she
We
at
do not
the
see-
time when she was major, my lord.
We don't like to continue further with this criminal petition. Consequence ensues if the lady is below majority,
No.
then consequence ensues to the place where the parents were living. And that if I interpret, that will be binding to the trial court. And to my, what do you say regarding this lawful guardianship? Because kidnappings are two kinds. One is from India, another is from lawful guardianship. And if any child
My lord.
is below 18 years, to whom the lawful guardianship belongs, it will be by this Guardians and Wars Act, perhaps.
No. None.
Law is like that.
But, my lord, when, my lord, her statement was recorded under 164 CRPC, my lord.
Why
was
once
measured by-
164 statement, whether it has any evidentiary value? What is the purpose? For
But
contradiction or corroboration, that's
Right.
all.
But, as per her deposition, my lord, all the incidents took
This
place-
is trying to delay the trial,
No, my lord. Purpose.
right? Every action has a reaction.
My lord.
Anything you can rebut that lawful guardianship does not remain with the parents if the child stays in a hostel. If you can establish, yes, I am ready to accept. But my view, tentative view is that unless because before 18, It is normally the parents who represents. Unless by some order, guardianship is given to somebody else because of the incapacity on the part of their parents.
Yeah.
No. Think it
May I
over.
pray for
Think it
another-
over. You show me. Otherwise, I have shown. I have taken you to entire provisions.
My lord,
Entire provisions.
my lord,
So show me only on this point. Otherwise, everything goes.
my lord, may I pray for another date, whether my lord, at that, when my lord, she was allegedly my lord abducted or kidnapped?
No, that determination of facts.
My lord,
On which date, we are not going into
My-
that.
my-
We are purely on a law point.
my lord,
PW says something, PW2 says something, we are not. It is for a trial court to decide.
my lord,
Why should we enter? We are in 482 or 528 or 447.
447.
447. 2-3 clauses. I have seen Roman 1 also. Consequence ensues. Consequence ensues at the place where trial is going on. Because parents live there.
Fine.
Okay, I am giving you another chance.
My lord,
You come. Well. Okay, Mr.
S.H. Sikdar, my lord,
Hmm?
S.H. Sikdar.
S.H. Sigdar, Planning Council for the petition, has sought a short accommodation for Mr. B. Sharma, additional public prosecutor for the respondent state, who is in attendance, has agreed to the safe prayer, list the case, on so and so as sought for. When you are next week?
Next week, my lord. Hello, President. Hello.
Next week, 13 Item 2.
May I please, Your Lordship?
Yes, yes.
Lordship, in this case, both the petitioner and the respondent are husband and wife, Your Lordship. There is a scope of reconciliation.
Hmm.
And
You
I
want
have instructed
petition?
to withdraw the.
Huh?
Yes.
Okay, good. If the wise sense prevails, better. Heard Mr.
Z.
C.P. Medi,
Zivor Gary.
Z. Borgore,
Borgore.
Council for the petition of post of Mr. Borgore has submitted that there is an element of settlement through conciliation between the parties. And in such view of the matter, the petitioner does not want to pursue the instant criminal revision petition at this stage. First of,
Your Lordship,
Uh,
divided in-
first of, he has submitted that the petitioner may be allowed to withdraw the criminal revision petition with liberty. In view of the above submission made by so-and-so, this criminal revision petition is dismissed on withdrawal, with liberty, as prayed for.
Obligation.
Item 3.
May I please,
Yes,
Lordship, this is an application for revision against,
revision,
yes, against an impugn order dated 10/7/2025.
take
As per-
7. Custody, interim custody,
Yeah, interim custody.
NDPS case,
Yes, interim custody of.
secret chamber. Good. You are
I am the owner of the vehicle.
owner.
And thereby Lordship,
So
I,
how, without your knowledge, a secret chamber can be constructed?
Lordship, firstly, I have not.
Charge sheeted.
Yes, charge sheeted.
What is the case number?
39/2025.
Where can I find that?
NDPS case number 39.
Okay.
2025.
It
And
will
I have
be
raised FIR along with my petition.
FIR. Let us see the FIR.
Lordship, on perusal of the FIR, the Lordship will find my name has not been mentioned anywhere.
Could be
And even in the charge sheet also.
in the charge sheet also.
Yes, I have not been arraigned as an accused or nor any kind of implication in which we could be found.
Recovered caustic. Where is the charge sheet?
Lordship, I have not annexed it.
Oh.
I have not annexed charge sheet.
Is it mentioned in the order that he is not a charge-seated person?
No.
Man, why didn't you annex the charge sheet? It could have given more information that you are not charge-seated. At
Yes.
least you have something to argue.
Due to paucity of time, I could not
Ah.
fix the charge sheet, Lordship.
You filed a charge sheet because the impugned order says
Yes,
charge sheet has been filed.
yes.
Miss Chetri, you are Miss Chetri?
No, that is,
Okay. You get file a fresh one with a charge sheet, you have the charge sheet.
the charge sheet may be called for.
No, better first we have to satisfy there is a secret chamber inside the bus.
Lordship, even then there is a secret chamber. The bus will serve no purpose lying in the custody. Firstly, your Lordship,
Hmm.
because the bus in question, I am the owner of the bus.
Firstly, no, yes, definitely. But whether that charge sheet will indicate
Yes,
that whether you were succeeded or not, right? Then the next step is whether it was with your knowledge or without your knowledge,
yes,
right? Thereafter, only 4 situations have been contemplated.
yes.
This situation is not contemplated. 4 situations have been contemplated now. Out of 4, in 2 situations,
Yes,
vehicle can be released in favor
Can be
of the client.
yes,
Registered
Yes.
owner. In 2 situations, it cannot be released, right?
yes.
It might get confiscated at the end of the trial. So please have the charge sheet on record,
Then Lordship, let me
because otherwise NDPS case records are more voluminous. Why should we give the trouble to the court, right?
then Lordship,
Machinery,
additional affidavit with regard.
whatever you want. Better comprehensive affidavit, madam. You are Miss
Al Banik.
L. Banik. You filed a charge sheet, we can find out from there that you are not charge sheeted. Then we'll proceed further. Right? Miss, Miss L. Banik. Yes, Mr. Goswami.
Lordship, it has to be.
But because it is half baked, half
Yes.
cooked,
Yes.
half cooked
Half
petition.
Lordship.
I am Mr. MP Goswami, Learned Additional Public Prosecutor for the respondent state coastal. The petitioner hearing the petitioner has approached this court after being aggrieved by an order dated 10/7/2025. Passed by the Court of Land Session Judge Karbi Anglong and Difu, whereby an application preferred by the petitioner seeking interim custody of a bus bearing registration number of so-and-so, case 17, has been rejected. First off, the petitioner has claimed that he is the registered owner of the subject vehicle. Full stop. From the order dated 10/7/2025, in the order, it is reflected that the charge sheet in NDP, charge sheet in Delhi PS case number 02/2025 has already been submitted. Full stop. Past insurance NDPS case number 39/2025. Full stop. As the charge sheet is not annexed with the instant petition, Ms. Monique, Learned Counsel for the petitioner, has sought liberty to withdraw the petition with liberty to file a fresh along with the charge sheet. First off, on record. First off, in view of the above submission made by Ms. Monique, Learned Counsel for the petitioner, the criminal petition is allowed to be withdrawn with a liberty to file afresh.
Item 4. May I please, Your Lordship?
What, how many occasions?
Yes, your lordship. Petitioner is shown as absconder in the charge sheet, your lordship.
NVWA? Or what?
Yes,
You were seeking what prayer?
prayer is your lordship, I want to appear before the trial court, your lordship. And as the charge sheet was made as showing me the absconder, your lordship.
No. IO cannot show you absconder.
But it is shown, your lordship.
No,
also-
that does not carry any value. That does not carry any value.
Yes, your lordship.
He normally says efforts were made to apprehend the petitioner.
Yes,
He could not be found,
Yes, yes.
like that.
2012.
Let us see the order, whether court has issued.
No, not yet, yeah. Court is issuing the summons, your lordship.
Oh, then,
It is 2000.
yes, mister,
Yes, my lord.
what to do?
Yes, my lord, only appearance.
2012.
Why you
FIR.
have rushed to the court spending money? Huh?
2012 FIR, your lordship. In
No, that is not the
2024
matter. Matter is that after submission of search sheet,
Yes, your lordship.
let us see the orders.
Only for
Page 30, 29/11/2024, issue summons to the
Yes.
accused.
Yes, your lordship.
Then continued, page
Yes.
31, all the four orders,
All
issue
the-
summons.
Yes, your lordship.
Then 32, issue summons.
Hmm.
So
Apprehension is there. He may.
apprehension, why? Summons has been issued. Court has not taken notice of that fact that IO has said you are absconder. Now, if you do not appear, you will become absconder.
Otherwise, he was not on previous bail, your lordship.
Not required. Summons means what? After your appearance, the court will accept
Your lordship.
your application and consider.
Dowry death
It is,
allegation-
it is the discretion of the court. You are at the stage of summons. You have nothing to do. Why you have come?
Only that much.
No
your
cause of action. Absolutely no cause of action.
lordship. Otherwise, he may be arrested, your lordship.
Some against the summons,
Yes.
IO cannot arrest you. On the strength of summon,
Yes, your
any police official cannot arrest you.
yes, your lordship.
100% sure.
Yes, your lordship. But court can be.
One day you have to appear before the court,
Yeah.
sir, and make an application that please allow me to go on bail.
That much. your
I'll
lordship.
appear.
Only
Why
observation-
should-
only
There is a
observation-
discussion. I cannot assume the jurisdiction of that court,
Only
trial
observation,
court.
your
No. You are
We-
trying to misuse
Facts of the
the.
case may be seen, your lordship. 2012 FIR was lodged, your lordship. In
I
2024.
cannot put the words in the order which should flow out from the trial court. I cannot write the order. It is the trial court who will write the order, pass the order on the basis of your application. But no cause of action. But Mr.
R.A. Mazumdar.
R.A. Chaudhary,
Mazumdar.
Mojumdar, let me answer for the petition. Yes, Mr. Sharma, anything?
Nothing, my lord.
How to treat this petition?
My lord. No cause of action, my lord. Be disposed of.
And Mr. B. Sharma, Land Additional Public Prosecutor, Gujarat State Post Office. Upon perusal of the materials on record, this court, it is noticed that in connection with Katigora Police Station case number 380/2012, the concerned investigating officer of the case submitted a search sheet. Full stop. On submission of the before the Court of Learned Chief Judicial Magistrate Kachar, Silsor. Full stop. On submission of the search sheet, police report case PRC number 3572/2024 has been registered. Full stop. In the charge sheet, the IO stated that there are privacy materials against the petitioner for the offense for commission of the offense under section 304A, Indian Penal Code. Full stop. the court of
Is it a-
the trial court. Oh, sorry, judicial mess. Sorry. অলপ ভুল হৈছে। On submission was charge sheet, comma, the Chief Judicial Magistrate Kasa S. Silso transferred the case to the court of Civil Judge Junior Division number 5, come Judicial Magistrate First Class Kasa Silso Trial Court for disposal. On receipt of the case record, comma, police report case number has been registered. On 29/11/2024, comma, the Learned Trial Court, after taking cognizance of the offense under section 304 AIPC against the petitioner, comma, issued summons for his appearance on 10/1/2025. Post on subsequent dates, comma, 10/1/2025, 28/2/2025, 19/4/2025, and, comma, 35/2025, and 37/2025. Sorry, 37 alike. The trial court finding that the summons issued against the petitioner had not returned, comma, ordered issuance of fresh summons, full stop, on 3/7/2025, comma, an application was filed on behalf of the petitioner by his engaged learned counsel seeking an adjournment, full stop. The trial court allowed the said pair for adjournment, fixing 7/8/2025 for appearance. Today is what?
Yes, today,
Today is what?
7/8.
7/8. Why you are here? Full stop. Having regard to the prayer made, the prayer made in this petition, the instant criminal petition under section 528 BNSS has been preferred.
Back here, na. Ate pera mo. What should be not allowed to appear? Seeking a direction to the trial court to allow the petitioner to go on bail in order to face the proceedings of PRC case, PRC number 3572/2024, presently pending before the post. Having regard to the order passed on the passed by the learned trial court, on the aforementioned date, comma, the petitioner, this court finds no cause of action for a petitioner to prefer the instant criminal petition. Post stop. Consequently, comma, the criminal petition is dismissed.
304B, Your Lordship.
304B. 304B. He should have been before the trial court.
Oblige. Item 5.
Yes.
May I please raise an objection? My lord, this is a criminal petition, my lord, challenging a complaint. Lord, initially an FIR had been
Why
lodged.
is all this so cause notice all
My
on?
lord, what has happened, my lord, I am a teacher, retired teacher. lady, my lord, around 61 years of age. Now then,
Let
allegation,
us see what is the FIR.
my lord, may be pleased to find the complaint is at page 111, my lord.
Objection against non-acceptable final report. What is the,
My lord,
then
actually,
what is the
happened-
FIR then?
Yes, yes, my lord, the FIR was 101. My lord, may be pleased to find page number 101.
Below notice, person serving has been serving as a resident teacher. A particular genuine matter, someone paid land was obtained a transfer certificate from Nahant and the state government she got admitted at Panbari. Subsequent years passed, the surviving on the same and to that evaluation, it is confirmed by the PR inspector of schools that there was no such incident as Madhir Sar. High Madrasa. For inquiry, but I know it gets suppressed by the inquiry legislation. As the government has referred or the manufacturer illegal so and so against person has committed an offense. So and so. Some non-existent existent madrasa. That is what the allegation is.
Allegation is that, my lord,
That is what the allegation is.
Yes, my lord.
Yes, then what
So
happened?
now, my lord, this has been inquired and the final report had been placed, but my lord.
Why is that final
unfortunately,
report?
Yes, my lord, that final report, we do not have the access, but my lord may be pleased to find that final report. Observation in the order dated, my lord, is page 109, my lord. This, my lord, IO has submitted the final report, my lord. Thereafter, the proceeding had been instituted, my lord.
Complainant.
My lord.
Okay, then he appeared.
My lord, then.
Then file objection.
File objection, this is the objection petition, my lord, is at page 111, which now, my lord, we are now before my lordships challenging the same, my lord.
No, after that complaint, what happened?
Yes, my lord, after the complaint, cognizance had been taken, my lord. The
Let us
order,
see informant Jurana.
my lord, the orders, my lord.
They
may be pleased
objected to the
find.
final report. Petition to is not properly investigated, submitted objection along with material witnesses. Counsel for the informant, peruse the case record, necessary order. Informant absent, peruse so and so informant is present. File fresh objection in connection with the instance is having a list of material witness relevant documents. Tag the same with the case record. Informant present, fresh list of witnesses. Tag the said is the CR. Consider matter of record, deems it fit to treat the objection petition. So final report was accepted and the objection petition
My lord.
or
On
whatever
acceptance,
Naraji petition,
my
protest
lord, it
petition
is amongst
has
the
been treated as a complaint case.
complaint,
Permissible.
my lord.
Permissible under law.
My
To
lord.
that extent permissible
Yes.
under law.
My lord, if it is, my lord, proved, my lord, then, but. my
No,
lord,
no, no.
Well-
This is exclusive jurisdiction of the magistrate,
That is correct,
right? To
Right.
treat it as a complaint case,
my lord.
not this court. Even Supreme Court cannot say stop him. Regarding material, that is a different thing.
My lord.
But he has the sole power to accept the final report.
No, we are not, yes,
All
my lord, we are
right.
not
So
against the power, my lord.
So
My lord.
the irrelevant point is not to be urged.
My lord, exactly, my lord. My
Right.
lord, I am not urging any
Right.
point, my lord.
So
My
let
lord,
us see the step by step,
My lord.
because I am slow to understand.
My lord, the
Inform as
order-
petition by
order said-
petition, face objection. Tag with the case record. Inform and present. NO. Okay, I have seen up to 125 then.
My lord. One.
Okay, complaint is present, heard,
Right.
perused. Case record, list of witness. Complaint is directed to bring the witnesses. Initial deposition. So initial deposition was done.
Yes, my lord. Is that page, my lord, 133, my lord, annexure 26.
Are also stated to be. Convenient. 18. Okay, how many 200? Okay. Complainant was examined.
My
Okay. Thereafter, owner is present,
last
file a
order.
petition. The leaser is findings in this case, all the officers who are required to be summoned in the petition. Where the complaint is allowed. Steps for issuance of summons for further inquiry. Steps for further inquiry, initial deposition. Tagged, Perus, who is CW2,
Court, my lord, it is court witness.
complaining witness,
My
basically.
lord, that complainant witness is the school of Mazerchar, from where I have been alleged to have obtained the degree.
Okay.
my lord, and an officials, my lord.
Let us see the statements. On what ground you have filed this petition?
My lord,
Tell
we
me.
have filed, my lord, because this is the first third party complaint, my lord. It is a matter relates to my service. Now, my lord,
That is RTI.
my lord,
That relates to RTI Act.
my lord, with all respect,
That is a different issue.
but here is a-
Don't bring in that RTI jurisdiction in a criminal
I-
case.
No, my lord, in a
No,
criminal
don't,
case, in a criminal, case-
don't, that is,
that is correct, my lord, but here is also.
your service particulars cannot be disclosed.
Cannot be
But
disclosed.
here is a question, the question is different.
No, my lord, he is a stranger to my service, my lord.
Okay, but it is every offense is an offense against the state.
Lord,
There cannot be in a case, is the informant is defined.
no, in a criminal case, my lord,
In a criminal case, informant is defined that
My lord.
Mr. A.R. Bhuiyan cannot be.
No, my lord, that is,
Huh?
Lord,
Cannot
if
be
I-
an informant for an offense against the state.
but this is not an offense, it is a private.
Every
dispute,
offense
my
is
lord.
a
My lord,
offense
kindly-
against the,
kindly-
yes. And there are some differences, some matrimonial, yes. The
My lord.
affected person is,
Private dispute, my lord.
affected person is private person,
My lord. My lord.
right? Matrimonial.
No, my lord, if my
In a
case.
check bounce case,
My lord,
the person affected is only the
private,
complainant.
my lord.
But other cases, it is offense against the state. Now let us have the statement.
My lord. My lord, initial deposition at.
Let us see,
One
page
thirty-
133.
133. May I read, my lord?
Yes, sure.
I am the complainant of this case. I had filed an Azahar before Dhubri Sadar PS on 25/12/2019, void FIR number 2206. The accused had forged her certificate relating to her studies at class 10 in the Mazer Chor High Madrasa School. Then I had personally inquired whether the Mazar Chor High Madrasa School was existing at that point of time. But after asking around the nearby people, I came to know that there was no such school. Thereafter, I filed an RTI and school department had given a reply that no such institution in the name of Mazar Chor High Madrasa School is present within his inspectorate. In the certificate which was issued by M. Ali, Superintendent of Mazar Chor High Madrasa School, I went to his residence at Kukrazar and upon inquiry he stated before me that no such certificate was issued by him. Hence, the accused has also forged the signature of M. Ali. Then I informed the matter to the then District Elementary Education Officer of Dhubri, but after receiving the no assistance, I also informed the matter to the District Commissioner of Dhubri, who appointed an additional deputy commissioner, namely Animesh Talukdar, and he inquired upon the matter and reported that the certificate furnished by the accused studying in class 10 at the Mazer Chor High Madrasa School is not genuine at all. The copy of report by the concerned additional deputy commissioner is annexed as Annexure 2A. On 1/3/1976, her age was around 18 years. The accused by forging the certificate had taken the job of being an Arabic teacher at the Panbari Rangamati Senior Madrasa and had gained unlawfully. At that time, her elder brother, Abdul Hamid Mullah, was the principal of the Panbari Rangamati Senior Madrasa. Then, upon the instruction of the Deputy Commissioner Dhubri, the matter was communicated to the District Elementary Education Officer, and then he instructed the concerned block elementary education officer who registered an Azahar upon the matter before the OC of Dhubri Sadar PS. However, no action was taken and no report was filed. Then, after receiving the copy of final report, I was dissatisfied and later filed a complaint case before the court in Dhubri. As per the documents, admit card, and any other related materials of the accused should have retired in the year 2018. However, he is still engaged in the aforesaid job, thereby misappropriating the fund of the government. The accused has taken the way of forgery and cheating of the securing the said job. I have furnished the list of witnesses in this case and who are acquainted with the facts of this case. I have lost this case so that the accused can be tried by the court of law for giving justice.
Next, CW.
Now, Milord. CW to assign. My lord may be pleased to find is at page 143, Milord. May I read, Milord? Where I am a retired government employee. 1. I know the complainant as well as the accused. I was appointed as the superintendent of the Mazarsar High Madrasa School for 1 year, and then I had joined another school of Sohens of Hassanirsar High Madrasa. The transfer of living certificate issued in the name of the complainant by the superintendent of Sohens Madrasa, wherein one M. Ali has signed upon the same, has not been issued by me, and the signature is not mine. Date of issue is shown as 10/4/1983, and at that point of time, I was not superintendent of the Mazarsar High Madrasa, and during that time, I was an employee at the Manipur Development Block, Bongaigaon. On 18/3/1983, I had joined at Manipur Development Block. I have not used or printed any register related to transfer or living certificate. Annexure A is not the certificate issued by me, and Annexure A1 is not my signature.
Then what is CW3?
Lord, CW3 is the 149 Inspector of Schools, Milord. Milord, he is not the inspector, but official of the Inspector of School, page 149, on oath. The current Inspector of School, Dhubri, namely Adit Kumar Sharma, has authorized and deputed me to appear before the court as per letter number so-and-so to adduce evidence in connection with this case. The Annexure A, which is the reply to the RTI by Juran Ali Akan complainant, was issued from our office, and the reply of the RTI was given on so-and-so, and the PIO has signed upon the same, which is marked as Annexure A1. In the said reply, it is mentioned that there is no such institution in the name of Mazarsar High Madrasa under the inspectorate.
Let us issue notice.
My lord, my lord. My lord, may I pray, till my lordship examine proceeding may.
I have examined already.
My lord.
I have already
My
examined.
lord.
It is a case of primacy case
My lord.
for issuance of process earlier under 204.
My lord.
And after going through CW 1, 2, and 3,
My lord.
at least on other legal primacy, on the case of finding a primacy case
My lord.
for issuance of notice, that standard appears to have been made.
My lord.
Any other legal point, legal point. So for standard,
My lord, I highly appreciate it.
regarding taking cognizance and issuance of process, that standard appears to have been made.
My lord.
Any other legal point like limitation, or legal bar,
Third
Yeah.
party, my lord.
that
My lord.
468,
My lord.
471, and you have, if it is say forced, and you have submitted before the state
Who has forced that?
to,
My lord.
no, that is a different, 71 is but first it has to be forced,
Tempered.
then using a document
To obtain.
as a genuine one.
My lord.
Somebody that point
Move towards me. My lord.
towards you.
My lord. That is correct.
Right. Any other legal point, say bar by this law, that law, you can say so. Otherwise, this CW 1, 2, and 3 at least, they
Against
have
me.
made out the case,
Fine.
primacy.
My lord, highly obliged.
You can only issue notice. Let he come.
Yes, yes.
If you have any
Then my
scope
lord,
for
kindly-
mediation, that is one thing,
My-
but legally at this stage, I cannot.
Then, my lord, I am praying for an observation that on their appearance, interim may be considered. That observation, my lord.
No, we'll decide.
My lord.
Only there is a deferment.
My lord.
If you can come up with that,
Strong
that
case, my lord.
legal bar,
My lord.
limitation, all this only. Otherwise, the final order is only deferred.
I can understand, my lord.
I am telling you straightly.
My lord.
I am telling you straightly.
My lord, my lord.
Come up with legal point.
Yes, yes,
Okay.
my lord.
So far as meeting the standard of primacy case, it is met.
My lord.
Yes, Mr.
The restaurant
Here,
number one.
here, Preliminary counsel for the petitioner. And Mr. B. Sharma, the additional public prosecutor for the respondent state. Post of the petitioner has the instant criminal petition under section 4528.
Yeah.
Read with so and so is preferred seeking setting aside of
Complaint case number, my lord.
the proceedings of complaint case number CR number 698 2022, presently pending before the court of learned judicial magistrate first class Chubri,
Hubri, my lord.
Chubri, and an order that will do. Issue notice returnable in 4 weeks. As Mr. Sharma, respond number 1. Respond number 2, informant,
Informant.
complainant. Okay,
Complainant. my lord.
complainant. Steps by registered post as well as by usual process within 3 working days from today. Post. You show any legal point?
My lord. I will.
Allow.
Yes. Sir. Oblige.
Item 6.
May I place your lordship? Lordship, this is a application under section 528 actually.
528.
528. Here actually the thing is that what I have stated is that the civil matter, it has to turn into a criminal one.
138 is always treated to be civil, but has been parliament by law
Yes, I do.
has
I
made
do
it
agree.
a criminal offense.
Yes, I do agree. But here the matter is a little bit
Oh.
different.
The facts behind any 138 case is civil in nature,
Yeah, that is true.
right?
That I agree. But here a matter is little bit different. Here what happened is actually the complainant had given me a loan and by an agreement which is made in page number 26 to 29. There were 2 agreements actually, 26 and 29. Here actually, first I was given at the 2% per year.
Hmm.
And on the next actually, I was given 1.5% per year.
Hmm.
Okay.
Rupees 5 lakh,
Yeah. 5 lakh.
page
And-
26.
Yeah. And in the
Mhm.
duration, I
Hmm.
had paid interest also. I had paid, this is a purely a civil dispute. I had paid the interest also. And the TDS on that interest also I have been paying. I had paid. Now, what happened? Since I was not able to pay some interest and all, the security check was bounced. Now,
What is the law regarding security?
here actually what happened is actually,
Security, it is there.
here all the facts, the circular, the law moves to the Assam Money Lenders Act 1934. I have annexed in page number 30.
You are a party to it.
Which one?
Right.
Yes,
You are a
I'm
party to it,
obliged. Yes,
right?
I'm a party to it.
With
Yeah,
your eyes open,
Yes, I have my eyes open.
disagreement,
Yes, I do.
right?
Yes, I do.
Huh?
I do. I am not saying that I am not due to this one. I am not saying that anything. This is what I am trying to say is that this is a civil matter. Civil matter because the thing is that
Obviously
the
civil
law-
matter, but the agreement itself says
come to page 27. The second party has further given 2/6 as security.
Yes,
Now, your
Yes.
case is these security 6 are presented,
yeah.
right,
One
for
second,
collection.
One
Now,
second, Mr.
for collection
Yes,
has been
you are-
used to institute the complaint
Yes, yes,
under 138,
yes,
right?
that's true.
Now, what is the law regarding security checks?
All the 138, the ABC has been done by them. I'm not
Right,
coming
that
on
is you have not questioned.
here-
Now, what is the law regarding security checks? He
The-
must have said that you failed to pay the amount on demand, perhaps. Then he presented the security checks. Must
Then
be
the
the
sec-
story.
Yeah, yeah. You're honest, totally
Right.
right on that. That's
Now,
also right,
this
Mr.
what is the law regarding what is security? Any debarment to present
No,
the
no,
no, I'm asking you.
No, you're not. there
I
is
have
no
not
such,
done any.
No, this security check, if at that time I had taken that amount only, this.
What is the law?
if I did-
What is the point you are urging?
My point of arguing is that one actually, ki the agreement which we had made comes under the money lender say, which the other fellow with that fellow, he was as per the law actually, he was not entitled to do so. Here I never say that
Raise the point.
yes, we have
Trial
we have
court.
raised the- Yes, we have raised the point, and in the if my lordship turns to a page
Because
number.
138 and 139 compliance is there. And it is a case
One-
of it has to be a case of rebuttal otherwise.
Yes, yes.
Right.
Your lordship.
On the
138.
standard of preponderance of probabilities.
Right.
Right?
Right.
So you get the complaint dismissed.
Your Honor, whatever you are saying is absolutely right. I do also agree. If your lordship can come to page number 34, because this was a loan given by an HUF actually. My lordship, please don't understand that I'm not trying to not give the payment to this one, but I'm just only trying the criminality does not come actually.
No,
In point number.
in 138, criminality is not there. Basically, it is a breach of trust or failure to pay the money. See, the behind the curtain,
Yes.
it is always the dispute is
Yes.
always civil in nature.
Yes.
And have you read the objection purpose of bringing 138 into the statute?
Yes.
Only because of that.
Yes.
That just criminal, it has been made a criminal offense. Because so that the negotiable instrument,
Yes.
the check,
Yes.
should be,
Yes.
can be used
Yes.
as a purpose of, for the purpose of business transactions, right?
It is absolutely right. And
That is what?
and that is absolutely right.
Purpose.
And that next line is that it has to be of a legally enforceable debt. Here, if my lordship page number 34 only thought this was the clause actually. If you could allow me to read it actually.
Yes, please.
In our HUF, because that person that there was an HUF, in our HUF, other members are minors. I have not to be authorized by a resolution by the co-personaries in respect of lending money from HUF to the accused person. As per our first agreement, the money was lent with 2% per month. I do not have any licenses to lend money. Out of our friendship, the money, so and so, this one, so. So my only this thing is that when the lending, when you are lending it comes under the law. It comes under the money lending law. So the recovery has also to be done by the money lending law. There is this thing. My humble submissions. My only this one humble submission.
Enact is a parliamentary law. Assam Moneylender Act is a state law.
Yeah. It's a that's
This is a matter of argument.
yes, sir.
I am to
I only
discharge
want to-
the burden of rebuttal
Yes.
by preponderance of probabilities and take all the grounds available to you to raise this point so that at one particular point of time, this can be considered by this court after everything is over.
Hmm.
But this is not a point to raise.
If my honor says so, I would like to close my argument over here.
Because firstly, he says in our HUF,
Yeah.
all members are minors, meaning that he is the person who has to take the decision. That is one,
Yes.
right? Second, He is not required because others cannot give resolution, past resolution, all are minors.
Lordship, in this, if I come to
Those
the-
are method of evidence. You cross-examine him.
Yeah, yeah,
thoroughly.
yeah, yeah.
Have you cross-examined him?
This is the cross actually. This itself is the cross actually.
Oh, this is the
This
cross-examination.
itself is the cross where we have stated it.
Ah.
like this one. This itself is the cross.
Okay, whether this will debar him, this lending of money is illegal. Lending of money and asking for interest, whether that illegality will prevail over the presumption
Hmm.
operation, which has been in operation by
No.
section 108, 113, all these are matters of decided by the trial court.
Lordship, I have said what I have written over here. The rest
No,
I
we will not
leave to the-
prejudice your case. We should not prejudice, but we don't think. If some observation is made, then that will influence the trial court.
Lordship, as per your wish. I could like.
Because
I
am-
do, I
I
have.
have to
I got
balance
your point.
everything.
I have got the court's point actually, and here I myself is the advocate over there. I
You
know.
take all the grounds.
Hmm.
This illegality of, say, some money lenders act, asking for interest, if you can show at the time of argument, it will be held in your favor. Why should we jump to the conclusion?
I mean, why I had applied.
Show me clinching law. Show me clinching law, any authority.
No, there is no such
Not
authority
authority.
as of right now.
At the time of appeal, we can examine, but I do not have any license to lend money. Then he can be proceeded with in a different manner. But you are also a party to it.
I'm also a party.
If it
I-
is if it is a, say, criminality, then you are a party to it. With your eyes open,
Yes. I have
you
taken it with eyes
entered
open. I have
into a
serious-
written agreement.
Yes.
All those facts are there,
Why-
sir.
Only what I wanted to say is that
Just
the
to escape
criminal-
the liability, invoke the inherent power which is to be exercised only in rare and exceptional cases, we don't find anything.
So it's-
Yes, Mr. Kaushik.
We have not made the party comment over here. We had made any
Okay.
comment, but we had only made the complaint in one party.
We generally, this court does not issue notice for sake of issuing notice. Right?
I could pray whatever the court like fits to do it.
This court does not issue notice just for the sake of issuing notice
It's okay. Whatever the court.
and
thinks-
adding one more in the docket. For adding one more. What is Assam Money Lenders Act?
The year actually, I have said, I have includes,
Here,
There-
let me examine the point. Show me.
which one, Maya,
Page 8, Assam Money Lenders Act,
Yeah, actually.
Section 7C1.
7C1, I have in page number 39 actually.
Hmm.
Here, it was amended in the year 1969.
Hmm.
This one. So here it says, 7C1, no
Ah.
person shall carry on money lending unless he holds a valid residence certificate in his behalf.
Get
He-
him punished with simple imprisonment up to 3 months.
Yeah. It was here
Ah.
in 7C2 that whoever does these things for the first time, 500 rupees.
File a complaint that this man has committed the offense under Section 7C1.
Yes, you were right.
Both of you will go together.
And both of us will go
Both
together.
of you will go together.
This will be a, what you call it, if I shoot, my heart breaks actually.
3,000.
This was also amended in the year 2022 also.
22.
That will be clear.
Lending.
Lending.
5
because
lakh. Why?
Only the 500
So and
rupees
so.
to 30,000 rupees and is 1,000 to something 60.
Raised a good point, but this agreement is of 2015.
15, yes.
So every law is prospective. So it is 7C1 only and 7C2,
2 years.
but you are a party to it.
Yeah, that's true. So it's like. if
And
I-
you are proprietor of an industry. So
Yes.
it cannot be said that you are an illiterate person.
No, no, no.
You are an industrialist.
Yes, yes. I'm in this.
Oh, in that
I'm in
case.
this. I'm in this. That is true.
Yes, Mr. You are Mr. Muzumdar.
Yeah, Ice Majumdar.
So we are taking it to its culmination.
As per this court things, I've land my.
It might
order of submission.
prejudice.
I have to give.
I will not be for your benefit. If I dismiss it with reasons, then it will be, it might be then detrimental to you. Think it over.
I do respect whatever the court says. I have given my
Okay.
viewpoints. I have
Hard.
nothing to say.
You are a regular practitioner here.
Yes, yes, I am a regular practitioner. I'm a advocate for the
Hmm?
banks actually.
Hmm?
I am an advocate for the banks and I was a recovery agent for the last 18 years.
Criminal petition under section 528. Bharatiya Nagorik Suraksha Honita is preferred. Seeking setting aside and quashing other proceedings of a complaint case, CR case number 2187/2019, presently pending before the Court of Learned Sub-Divisional Judicial Magistrate Roman to Kamrup within bracket Metro at Guwahati, wherein the petitioner in the complaint case, CR case number so and so, the petitioners herein are petitioner herein is arrayed as accused number 2. First off, the respondent impleaded herein is the complainant in CR case number so and so, and he instituted the complaint alleging commission of an offense under section 138 of the Negotiable Instrument Act 1881 as amended. Full stop. In the complaint, the complainant had asserted that he advanced the sum of rupees 5 lakh to the accused on 21/9/2015 by a check bearing number 153166 dated 21/9/2015, drawn on HDFC Bank, Fancy Bazaar, Guwahati. Full stop. He had further asserted that the said the accused had duly admitted and acknowledged the receipt of the amount by issuing a money receipt dated 21/9/2015 with a promise to return the aforesaid loan amount within a period of 12 months, along with an interest at 2% per month, which was later on verbally finalized for 1.5% per month. Full stop. A deed of loan agreement was also executed between the parties on 21/9/2015, page 20. It was further averred that the accused for repayment of the aforesaid loan amount had issued a check bearing number 4067 of rupees 5 lakh drawn on Federal Bank Limited, Silpukuri, Guwahati, in favor of the complainant's HUF firm on the date of execution of the aforesaid agreement against his outstanding liabilities. Full stop. It was after dishonor of the said check on its presentation for collection, the proceedings under Section 138 of the NI Act has been instituted by the respondent as complainant, provide the complaint registered as CR case number so and so. Para. In the complaint, the petitioner, while arraying the petitioner as petition number 2 as in the capacity of proprietor of Messrs. Dev Industries, the petitioner's proprietorship concerned, Messrs. Dev Industries, has been arrayed as accused number 1. This complaint is part of the case record. Sorry,
Yes.
check.
Yes.
Is it there annexed somewhere?
No, the check is not.
Not annexed.
Arranged.
Okay. Para 1, the main ground alleged, main ground urged by the learned counsel for the petitioner while setting aside and quashing of the proceedings of CR case number so and so is that the act of lending money by the respondent complainant to the accused persons with the provision for interest has brought the act within the purview of the Assam Money Lenders Act, 1934, as amended. Full stop. It has been urged that Section 7 within bracket C, capital C, within bracket capital 1 of the Moneylenders Act has stipulated that no person shall carry on the business of money lending unless he holds a valid registration certificate in that behalf. Full stop. Subsection 2 of Section 7C has provided that, page 40, whoever contravenes the provisions of subsection 1 shall be punishable. So and so. Full stop. it is it is provided in section 12, sorry, 7, no, 12, capital A, within bracket 1, that it has been provided that no court other than a court of magistrate of the first class shall take cognizance of or try an offence under the Act. Full stop. Subsection 2 of section 12A has stipulated that no court is 41%. Shall take cognizance of any offence under the Act except on a complaint in writing made by an aggrieved person or an officer not below the rank of a sub-inspector of police or by the registrar or any other officer specifically or generally authorized under on that behalf by the state government. Full stop. On a query made to the learned counsel for the petitioner, the court has made a query to the learned counsel for the petitioner whether any complaint in writing as per subsection 2 of section 12A of the Assam Moneylender Act has been instituted, tried, or concluded by after a complaint, after any complaint instituted by the persons named therein. Full stop. The answer, the learned counsel for a petitioner has answered in negative. Full stop. What is the definition of aggrieved person?
Yeah, the definition of aggrieved.
Do you have the act?
Actually, this is the amendment 9.
Do you have the mean act?
No, no, Your Honor. No,
Huh?
Your Honor. No, Your Honor.
Whether you fall in the category of aggrieved person, I have to see.
This
Assam
19
Moneylender Section
1934, you can find it on
You should have been equipped with the act.
Your Honor, I have only bought from the amendment part. 1934.
I have already quoted the amendment part.
Yeah.
Now, definition of aggrieved person, whether you really fall in the category to allege this kind, then this will put further embargo on your case. Someone in yes. If you don't fall,
I just got that one. If I don't fall under the aggrieved person, but the aggrieved person,
it
I
might
want
be
to-
because let us see
Yeah.
who are
It's only 6 pages so long, I think. So.
let us have a printout.
Your Honor is right. I fall in an aggrieved person. And
Because the other authorities have not
yes. You're right. Your Honor.
instituted any complaint. Only thing remains is the aggrieved person.
Agree.
Whether you fall in the definition of aggrieved person, let us see aggrieved person. To raise this point at all, because he has to be tried,
Yes.
complaint needs to be instituted,
Instituted,
tried,
right.
and the trial is to be concluded.
Yes.
To
Yes,
hold
sir.
him as a money lender. Have you understood?
Yes, we have to first file a complaint. If I am the aggrieved one, I don't, yes, I have also not gone through. Is it true?
Please, please,
Because
please,
it's 6 pages. So
read it loudly.
There is no definition of aggrieved
aggrieved
person.
person indeed, because it is of 1934, Your Honor.
34.
At that time.
That, then it is doubtful.
Only 4 definitions are here, my lord.
Who is a money lender, who is a people.
Oh, you have to see the money lenders like 1934.
34,
Definitely there will be. You have enclosed only the amendment, right?
Yes, the main is 6 pages, I think.
Definition is not provided.
Not provided.
Moneylender Act, then any rules framed?
Your Honor, that I don't know. That I don't. I have gone through this act actually. I have also not memorized that I have seen agree one.
Master line to KSL. Amendment. Money lenders. ঠিক আছে, amendment. It will amendment নহ'ল। Rule making power was there. Negative, তাৰপিছত কি ক'লো? তাৰপিছত কি ক'লো? Negative. Negative. Full stop. In other words, comma, there is no finding to the effect that by a court of competent jurisdiction, comma, as on date, comma, to the effect that the respondent, complainant is to be treated as a money lender. Full stop. Para. It is noticed from the materials brought on record, it is noticed that the deed of agreement, petitioner or petitioners are a party to the deed of agreement executed between the petitioners on one hand and the respondent complainant of one part and the respondent complaint of the other part on 21/9/2015. Full stop. The agreement, such said deed of agreement,
Where is that mention of interest?
Interest part is there.
Huh? Where is that?
It's
Mentions about,
Mentions-
mentions
mentioned.
that the petitioners would pay
2%.
an interest of rupees 1.5% per month on the loan amount every day. Full stop. Whether such recital would bring the respondent complaint within the purview of the definition of moneylender. Is a matter which can be decided only as per the procedure, which can be determined only as per the procedure laid down in the Assam Moneylenders Act 1934. Full stop. Para. In view of the discussion made above, this court does not find any ground, not to speak of good and sufficient, not to find any reason, not to speak of much less good and sufficient reason to entertain the instant criminal petition, to invoke the inherent powers under section 528 BNSS. Post of the trial at this stage, as the trial, as the proceedings of CR case number so and so is still on. Full stop. The trial court, as the trial court is in seizing of the matter, the petitioners, single petitioner here,
Single
the
petitioner.
petitioner is at liberty to raise all grounds during the proceedings of so and so. It line agadiva, under the law, not entertained.
For admission, item number 8.
Appeal heard Mr. S.A. Ahmed